Hello, hello, and welcome to Crime in Court. My name is Heather, and this is an update on one of the latest filings within the DELPHI case. So, last week we had multiple filings, so I did one video with all of the filings, so I'm going to link it here. And I just wanted to let you know that if you missed that, you might be slightly confused. So I'll just give you a little overview. We went over, I think, 4 documents, most of them from Richard Allen's defense team's defense counsel. So they have hired defense counsel, and they are trying to deal with this contemptuous conduct accusations that they're having to face from prosecutor Nick McClelland, and obviously we already feel like we have a very biased judge, so they don't have a very good shot. But you can't take them off the case because the Supreme Court just put them back. So who knows? I don't know. I don't know what they're thinking. I really don't. But anyways, thanks to the defense diaries, Bob Mott and the defense diaries, he had a copy of this filing, which is in response to so Nick McClelland, he wrote a filing, and we read that in the last one, where he wanted to he was asking the court to compel discovery from the defense side, which that's not the way it works. It's not like reciprocal discovery. That's not how the rules work. It's like the state gets their information from their investigators, and then they give that to the defense, and then the defense can go out and do their own investigation and keep that discovery to themselves, because that's part of their defense strategy. That's not necessary, or potentially. So it's not necessary that they provide that to the state, if I'm making sense. I'm hoping that I'm clearing that up. So the fact that Nick McClelland is even asking for discovery is like, what? We all went, what? When we read that. So this is, again, thanks to Bob Mott with the defense diaries. He had a copy of this, but then this person, Measurement the 1 day ago is when they posted it. I thought it didn't look like there was a space there. So Measurement is the one, thank you Measurement, for typing it up and letting us read it off of Reddit now. So I'm going to read this latest motion, which is in response to having to give you my discovery. No, I'm not going to. It's basically what they say. It's a big FU, and it's pretty great. So let's read. So, all right. This is coming from attorneys Andrew Baldwin and Bradley Rosie. Comes now the accused, Richard Allen, by and through counsel Andrew Baldwin and Bradley Rosie, and files his response to the state's motion to compel discovery. On January 27th, 2024, the state of Indiana filed a pleading entitled State's Motion to Compel Discovery, requesting until February 26th for a response. On February 8th, the court ordered defendant to respond to the state's motion to compel discovery on or before the 21st, or provide the discovery requested. Okay, so the court has compelled them to, she ruled in favor of the state and compelled them to turn this discovery over. And I don't know why the dates changed, but it changed from the 26th to the 21st. Anyways, so the defense attorneys on this matter were reinstated January 18th, 2024. So they were just reinstated. And then 12 days later, January 30th, 2024, the defense received the bulk of the discovery in the form of multiple hard drives. In addition, between January 29th and January 31st, the defense received 3 separate e-discovery emails from the state, all of which contains volumes of audio, video, reports, transcripts, and other documents. So they're still sorting through all this discovery. What really irritates me is that they had all their discovery. I'm sure it irritates them way more, but they had all their discovery planned out, organized, categorized, labeled however they wanted, exhibits filed with numbers probably the way that they want, and things like that. So it's just a kick in the face that Judge Gull ordered all the discovery to be returned to the state when she ordered them off of the case without any choice, and unconstitutionally against Richard Allen's rights to his defense counsel. So when she took away that discovery, they did who knows what with it. Now it's not in order anymore. Now it's not categorized the way that they had it. They have to search for the things that they want again. And on top of that, they received a lot of new discovery that they haven't received before. So let's read what they say about that. So after reviewing just a portion of the evidence contained on the hard drives and discovery drops, it became apparent to the defense and the discovery received includes evidence that the defense believes it has never viewed or had a chance to view. Perhaps between September 2023 and January 18th, 2024, the state of Indiana provided this evidence to counsel that replaced attorneys Rosie and Baldwin, ? And I like that because it's like, we're not saying you did anything wrong. Maybe you gave it to the other attorneys when we were kicked off the case, but regardless, we haven't seen it. So there we go. All right, so the state and the defense are also in ongoing communications regarding evidence that may exist but has not yet been found by the defense. Hazel. I don't know what she's doing. She's walking around and annoying my other dog. What are you doing? Go lay down. All right. Sorry. So the state and defense are also in ongoing communications regarding evidence that may exist but has not yet been found by the defense. So they probably, in their exhibit list or whatever, turned it over to the defense, and then the defense is like, where are these exhibits? We can't find A, B, and C. Where is it? So they may have never received it in the first place. The volume of discovery is massive, including minimally 20 hard drives as well as 6 separate e-discovery emails, and as of the date of filing, the defense has had less than 3 weeks to review the discovery. In terms of the state's request for the defense to provide a witness and exhibit list, the defense would seek an extension of time to file its preliminary witness and exhibit list until Monday, March 25th, 2024. This will hopefully provide the defense enough time to review the massive discovery to determine what witness it may call at trial, including expert witnesses, and what exhibits it would expect to introduce. Certainly, so they're asking for more time. Certainly, the defense wants to accommodate the state's request, especially as it relates to the state's need to react to any expert witnesses that the defense may present at trial. The defense believes that by March 25th, 2024, the defense should have a much better grasp of the discovery it has received, and therefore a much better grasp of what fact witness and expert witnesses it expects to call and what exhibits it may introduce. To show evidence of good faith, the defense has already provided the state of Indiana with the names of certain expert witnesses and other witnesses that the defense certainly plans to call at trial. The information was provided to the state of Indiana on or about February 14th, 2024. So we're saying we can't give you the list right now because we can't provide all this discovery that you want because we're still looking through the discovery and evaluating it. So you got to give us a little bit more time, but we understand that you still need to hire expert witnesses to rebut ours. So we are giving you a list of what we have so far, and by the end of next month, we'll give you the rest of the list, is basically what they're saying, which I think makes sense. All right, so in this motion, the state of Indiana also requests that the defense provide the state of Indiana in evidence notice of any exhibits concerning which the defense intends to question the deponents. So this is the key part here that I really love, and we got to pay attention. So yes, the state of Indiana has asked for their discovery, their exhibits and all that. They want to know what's being used, which you never do that. So here is the defense's response to this, and it's great. The defense does not believe this request is legally sustainable, as no local or trial rule mandates that either side is required to turn over exhibits before depositions. Additionally, providing the deponent an opportunity to review certain exhibits before the deposition takes away the spontaneous responses of deponents that often reveal dishonest answers that are later useful at trial. So, you can't get honest answers and later, impeach them if they were lying. That's the whole point of the deposition. Well, not the whole point to impeach people, but to get to the facts and get, see how people's stories change over time and whatnot. So, all right, so when deponents have a chance to prepare for their answers by reviewing evidence ahead of time, the answers are no longer spontaneous but are prepared. And that is an excellent point. The defense would object to the state and deponents from having a preview of any exhibit the defense plans on introducing at deposition as violative of trial strategy for both sides. Wherefore, the defense would request until March 25th, 2024 to provide the state of Indiana with its witness and exhibit list. And again, that was attorneys Andrew Baldwin and Bradley Rosie for accused Richard Allen for the DELPHI unalivings. So there's so much other stuff happening in the background that Richard Allen's case is kind of getting pushed to the side because they have to figure out all this other stuff, and I'm sure it's irritating to the victims involved, the family members of the victims involved, the accused, his defense team. I'm sure it's irritating for the town not to have some answers and some conclusions, and it just seems like there's a lot that the state is hiding or trying to do to, insert themselves into this case somehow. I don't know. What do you guys think? Please let me know in the comments below. I would love to hear your thoughts about the DELPHI case and all this other legal stuff going on in the background. Please like, comment, subscribe, and I hope to see you next time. Thanks so much. Take care.